At 6 p.m. Oh, give me just a second. Where is it? Is 6 p.m. Where's my agenda? Do y'all have an agenda so I can read out? Here it is. I pulled out everything but my agenda. The time is 6 p.m. and I will call the specially called meeting of the Mayor and Council appeal hearings of application for license to sell alcoholic beverage by the package for the city of Snellville, Georgia, Monday, September 11th, 2023. So we've called the meeting to order. We do have a quorum. All members of the council are present. So we will begin the appeal hearings. They will be addressed in the order that the appeals were received. Do you want to give the format?
Sure.
Real quick for the public?
So the format for tonight, this is a non-adversarial proceeding. What that means, I don't usually get to do that. What that means is there's not going to be witnesses called to the stand. This is not a court of law. There are not rules of evidence. This is simply an appeal of an administrative decision that was made by the city manager. And when we begin, the mayor will call the name of the case, and then the city manager is going to briefly bring up what the case is, the name of the appellant, and what his basis was for denial of the application. At that point, the members of the mayor and council will have an opportunity to ask the city manager any questions. Once that is completed, then the appellant or their representative will then have an opportunity to present their appeal. They will have 30 minutes total. If questions are asked during the presentation, the time will be paused so that the applicant will be entitled to their full 30 minutes of presentation time. After they're completed, again, there will be an opportunity for questions from the mayor and council to the appellant. After the appellant has completed their side of the issue, then the mayor and council will entertain any motions to either affirm the decision of the city manager or to overturn the decision of the city manager. Should any of the appeals be overturned, those applications then will move forward and be placed in what we're calling the hopper at this point in time, but for the random selection of an alcohol license at the September 25th council meeting. So.
Thank you, Mr. Ross. So we'll move to our first case, and the first case is Mr. Seth Wiredew. I apologize if I did not pronounce your name correctly. It's Nico's Wine Depot, Snellville Beverage, 1890 Rockdale Circle was the application. Mr. Sanders.
Mr. Redo is the first of four appellants tonight. His application was reviewed the same as the other three. Basically, we took the ordinance number 2023-04, which was adopted February 27th. We took the stated requirements and the standards that were within, and we reviewed each application based on those standards, whether they were met or not. This was done internally, mostly through the planning department and the police department, the two departments that are most applicable to this business once it gets started. And basically, Mr. Redew's application was short in several areas. They were: no site plan was provided, the proposed location lacks direct access to a traffic light, no easement connection was provided, required insurance was not met, and application was incomplete. Those were my findings, and I will just turn it back over to the appellant and the council.
Thank you, Mr. Sanders. And now we'll hear from the appellant. Oh, I'm sorry. Just 1 second. Council, do you have any questions for Mr. Sanders? Thank you. If you will state your name and address for the record, please.
Yes, ma'am. My name is Sheila Francois, and I'm here with Mr. Seth Redu. My last name is spelled Francois, and Mr. Redu is here on my right. He's joining me here today.
And your address also, please.
My address, 4213 Scenic Mountain Drive, Snellville, Georgia, 30039.
Thank you.
Thank you. Mayor Bender, Mayor Warner, and all the distinguished members of the council of the city of Snellville, we would like to thank you for your continual work in improving the city of the Snellville and for creating opportunities to support small businesses and for working hard to create a thriving and successful city. Before I begin, I would also like to thank you for the opportunity for giving us the opportunity to briefly explain the circumstances for which caused the denial. And today we are asking that the city manager Sanders' decision to deny the application be reversed because the application was complete based on the ordinance as it was published in March of 2023. Furthermore, there were a few misunderstandings that today we're hoping to clear up. And although the ordinance was amended and was not published until April 2023, Mr. Redu nevertheless already had completed the additional requirements, which is the reason why we were able to submit everything relatively quickly. In March 2023, Mr. Redu came to the city of Snellville to pick up alcohol survey, the ordinance, and the alcohol license application, and went through the checklist. And at that particular time, the ordinance had not been amended. And so based on the language that was in the ordinance in 2023, he subsequently submitted his application. As it relates to the three particular issues that was addressed in the denial letter, first, the fingerprinting. The fingerprinting was developed and received by the city. We have already spoken to the Planning and Development Administrative Assistant, Ms. Nellie Wilson, who also confirmed that she had actually received the fingerprinting with the initial report. We also spoke with the city of Snellville Police Department. They gave us a copy of the report, and they subsequently sent a second copy over, and Ms. Neely confirmed that she received both copies. Given this misunderstanding as to this particular issue, we're asking that the manager's decisions be reversed. The second issue relates to the proof of insurance. The required liability insurance provided is sufficient for the particular type of insurance that the city was asking for. The only difference was that Mr. Redu planned to purchase an undeveloped property. So the insurance that we provided, the address that's on that particular insurance is the business, the current wine and beer business that he currently operates. He had a concern that if he transferred this address to the undeveloped land, that there would be issues with compliance. And also, as the ordinance was written in March, it did not initially afford or allow for a quoted proof of insurance. And given that the only discrepancy with the insurance is the address, because it's the same exact insurance plan, the only difference is the address now says the future store location address, we're asking that the city manager's decision be reversed. As it relates to the last issue, which concerns the survey and the site plan, Mr. Redu was aware that a site plan was required, and hired an agent, hired a surveyor in order to review the ordinance and to be in compliance with the standards and regulations set forth. This particular engineer was actually recommended by the city and the same surveyor that also worked on Mr. Redu's beer and wine store that he currently has. And he asked Mr. Redu whether or not, based on his experience with the city, whether or not the city wanted a full site plan or the concept site plan. Mr. Redu reached out to Mr. Jason Thomas, Thompson, the Planning Development Director, to clarify this particular requirement, who stated that the concept plan is sufficient, and based on this information provided through an email correspondence, he submitted the concept site plan. I do have copies of that email. If I may approach, I have 7 copies I would like to provide. On the very last page, you can see where Mr. Redo reached out to Mr. Thompson. Well, where Mr. Redo reached out to the engineer survey and gave the engineer survey the particular requirements for the site plan. On the very first page is where you will see Mr. Jason Thomas says that a concept plan is sufficient. And given this information we have received in the denial letter, we nevertheless were able to quickly develop that site plan within a matter of days. Significant due diligence has been made with respect to identifying the risk and the liability of the new location, and as a result, we are asking that the city manager's decision be reversed. He hired an agent in April of 2023. The property was located in May 2023. The contract to purchase land was signed in on May 11th. A pre-approval for a loan related to the purchase of the undeveloped land was received on August the 2nd, 2023. And we have copies of all of those documents with the initial application as well as with the supplemental with the appeal. We received a denial letter on August 2nd, 2023. We submitted the appeal letter along with 2 printed copies of the blueprint for the site plan and quoted insurance. We also provided, along with the appeal packet, 2 digital formats of the additional supplemented copies onto a flash drive. And in conclusion, the city has afforded Mr. Reedy the opportunity to operate Nico's Winery Corner, a wine and beer store in Snellville, for 2 years, and he has become accustomed to maintaining compliance as it relates to standards and essential functions in his day-to-day operation. We certainly, and us missing these few items certainly don't excuse not having it, but for the fact that the amendment was amended, these issues, these misunderstandings would not have occurred. Because of the support from the community in the past 2 years from the sales and community engagement through wine tasting and educational events, he's able to manage and operate and seek opportunities to grow the business. A reversal for this application will provide the opportunity to expand the business and to grow in the type of the sale. So as he continues to seek opportunity to grow the business, he's also dedicated to providing the staff with the best working environment, each customer with the best possible experience, and we hope to have the city's support in the new opportunity to grow the business and grant a reversal. Thank you.
Thank you. Are there any any questions of the council for the applicant? Mr. Warner? Or Ms. Schultz?
Yes, yes, ma'am. Did you address the issue of interparcel access?
Yes, ma'am. It's in the site plan. So initially it was on the concept. Well, when we initially submitted the concept plan, it was not in there, but it has been addressed in the site plan, the subsequent document that we provided. All of the criteria that it was related to the site plan and concept plan, we have provided an updated site plan addressing all those additional requirements, which is the ingress, egress, the entryway, all of that stuff has been updated.
And when was that final site plan submitted that showed the interparcel access?
We submitted the appeal. On August the 11th, along with the blueprint copy of the full site plan. We provided a printed copy as well as digital copies on a flash drive to Ms.
Mr. Sanders, what was the deadline for submittal?
The letters went out on July 31.
Well, were you asking about the deadline for the submittal for the application?
Yes, for the application. I'm trying to determine when the information on the interparcel access, if it was submitted after.
I think what she's saying, and clarify if I'm misstate this, the application was due on June the 5th, and they submitted the interparcel access on August the 11th with their appeal. Is that what you were asking?
Yes, that's what I was trying to get.
And Mr. Warner, you had a question?
My question has now been answered.
Thank you. Any other council members that have a question for the applicant? Okay, thank you, ma'am.
Thank you.
So we've heard from Mr. Sanders and the applicant, so we are ready to make a motion. I'll take a motion and a second, and then if there's any council discussion, we may have that as well.
Madam Mayor, I defer to Ms. Linsky.
All right. Motion to uphold the city manager's decision to deny.
Second.
All right, there's a motion to uphold the city manager's decision and a second. Any further comments by council? Then seeing none, I will ask for a vote. All in favor, please raise your hand. That is 6 in favor, so none are opposed. The city manager's decision is upheld. Thank you all for your time. Now we will hear case 2. This is Mr. Donald R. Camp, Snellville Beverage Store at 1945 Fars Road. Mr. Sanders.
This was an application that was reviewed in much the same way, and it was found to be lacking in several areas. Specifically, as I wrote in the letter, the application is denied because application is incomplete or inadequate. Site plan is not provided for the proposed use. No boundary survey was provided. Fingerprinting and background investigation information is incomplete.
Any questions of the council for Mr. Sanders? Nope. Then the floor is all yours.
Thank
If you'll
you.
state your name and address for the record, please.
Matt Reeves, Anderson, Tate and Carl, 1 Sugarloaf Center, Duluth, Georgia. Mayor Bender and members of the council, I'm proud to represent Dwight Harrison, Donald Camp, Mr. Ron Harrison of Loganville Beverage Store, and Lanier Flanders is my co-counsel in this matter. The city has an ordinance about package stores, and that ordinance has certain provisions about accepting the application to go into the lottery. I know that the way so far this process has been explained, you've been asked to be in the position of either supporting the city manager or overruling the city manager. What I'm asking you to do tonight on behalf of my clients is accept this application as compliant to go into the lottery. And the reason I'm asking you to do that is you need to look no further than the next city down the road with liquor stores, Loganville, to see what could happen if things go wrong and there are legal issues. Loganville intended a few years ago to give out 2 liquor store licenses. I know right now the city's intending to give 1 away, and there's a drawing on September 25th. If there are legal issues that remain unclear, and if a judge says that application should have been accepted, then the city could end up having to grant additional licenses, more licenses than you intended. But on the other hand, if you grant the appeal and you accept the application as eligible for the drawing, that could eliminate the city having to give more licenses than it intends. So the way the ordinance is written, the real question is it a compliant application as of tonight not is the city manager wrong or right. That's too narrow of a legal analysis, and it could end up getting the city in a legal fight unnecessarily. And so here is our application and our appeal on behalf of Snellville Beverage Store, which is a sister company of beverage store of Loganville, and I'm going to have Mr. Ron Harrison talk a little bit about the benefits of having a nearby liquor store operate too, which can serve the customers. There are two main issues in the appeal, and that is the site plan and the survey. And on page 2 of the appeal letter, I brief the issue of the site plan. That's in Exhibit B of the appeal, and page 2 at the beginning of the letter. With the initial application, and I filed the initial application as Exhibit A of my letter. The initial application was 90 pages long. When I made an open records request after my client got the denial letter from Mr. Sanders, what I got back was far less than 90 pages. My client sat down and looked at what the city initially gave, and they said, we had a checklist that we provided. And so when we followed up, we got the 90 pages that is before you. And so there is some question about what was reviewed when that denial letter was sent out on behalf of my client. But if you'll look at Exhibit A, pages 89, I believe, let's see, 86, 87, 88, and 89, you will see there initially with the initial application back in June, there was a site plan from Paulson Mitchell Engineering, and it showed the property laid out. And by the way, this property in this application, it's the same property as Nico Patel's property, which the city has already accepted for the lottery. And so there's no question about access or zoning or the substance of this property. But my client submitted the Paulson Mitchell site plan back in June. And this site plan, which is highlighted in yellow on page 86 and 87 of the application, it showed curbs and gutter, it showed a building, it showed a parking area. It was laid out. The city asked, do you have enough building space and parking space and ingress and egress? That was the reason to ask about the site plan. And this site plan shows access, ingress and egress, it shows parking, it showed the building. With the naked eye, you couldn't see the square footage, though. When Mr. Sanders raised that issue and we got the magnifying glass out, we realized that site plan did not show the square footage. So in Exhibit B, as you can see, we asked Paulson and Mitchell, tell us more about that building on your plan. And Danny Mitchell of Paulson Mitchell clarified that building on that site plan is a 31,790 square foot building. The city's requirement was 10,000 square feet. My clients intend to build a 10,800 square foot building, and they provided plans to that effect with their initial application. So this building that's shown on the site plan actually could fit a much bigger building than what my clients propose and what's needed. And so what they did is they asked Paulson and Mitchell and Hill, Foley, and Rossi to go back and clarify if you're just doing a 10,800 square foot building, what would that look like? Because the square footages weren't clear, and we found out that building on there was a lot bigger than needed. They presented the page 1 in Exhibit B, a 10,800 square foot building with ingress, egress, parking, building space. All of that was compliant. Additionally, we found out, based on the question about the building size, that there are easements in this development that allow overflow parking in those restaurant parcels. As you may know, you've got Hampton Inn across the street, you've got Cracker Barrel, you've got Outback, you've got Zaxby's, you've got Freddy's. There are easements that allow overflow parking in those restaurant spaces if there's a need for that. So we actually initially presented an engineer's plan of a bigger building, and we clarified that once Mr. Sander asked questions. So it's not that we didn't present a site plan initially. That site plan initially showed a bigger building than needed, and we clarified it, and you can rest assured that my clients have presented the city with building size, ingress and egress, and parking sufficient for a liquor store on this site. Additionally, the city accepted this property already through letting Nico Patel's application go into the lottery. And you may ask, well, how can Mr. Patel have the same property? Both my client and Mr. Patel are contract purchasers of that property. The two contracts are contingent on who wins the lottery. So that's how both properties are in that. But the next two appeals you're going to hear have questions about the property. This issue is not at question. So that is the issue about the 10,800 square foot building and the site plan. The issue about the survey, as you can see on pages 88 and 89 of the initial application, there was a submission from Axis Infrastructure, and their document was entitled Distance Exhibit. And Dean Collins is who runs Axis Infrastructure. He is the chairman of the Gwinnett County Chamber. And as you could see on page 88 and 89, there is a surveyor's seal on that property. Under Georgia law, a seal by an engineer or a surveyor, those are regulated industries and they are swearing it's accurate. My client thought that that survey, stamped by a surveyor that had a lot more detail than several of the other applications that were accepted, that was compliant with a surveyor's certification regarding distance. As you can see, there were a number of distances that were outlined in that exhibit. But if you turn the page to Exhibit C, at Mr. Sanders' request, we went back and got the affidavit done by the surveyor. That surveyor was unfamiliar. That's not a usual request by a city. My client was not familiar with that, but we got the affidavit done. But initially there was a survey and there was a distance certification by a licensed surveyor that the school and church and other guidelines were followed for the site. Additionally, the city saw in Nico Patel's application that this site did comply with distance requirements. So we initially did file a survey with a surveyor's seal, which is the equivalent of sworn testimony. They're putting their license on the line, but we went back and got that affidavit. Now let me point out, if you look at the end of Exhibit C, I've shown you the affidavit that came in for Nico Patel, and y'all have already put Nico Patel's in the hopper. And I would ask you, look at that affidavit and that sketch with some typewritten things next to it, and look at that, and then look at what my clients presented back in June. And my client's submission back in June was at least as detailed, but I think it's even more detailed. They had a aerial photograph and they had certifications, and it was more informative than what one of the other winning applicants had. So both on the issue of the site plan and the survey, the initial application was sufficient, but based on the letter that we got from the city, it's certainly compliant with the supplemental information. The issue about the fingerprints, Mr. Harrison's fingerprint and background check came through the first time, no problem. Mr. Camp's fingerprint and background application, it got returned and he timely submitted a replacement for that, and then he didn't hear anything. You know, the first time that there was a technical error and it didn't go through, he heard back, so he went back in and got it redone. But then that one didn't go through, but nobody told him that until Mr. Sanders' letter. And he promptly went back and got it fixed after he was notified by the city that the second one didn't go through. So it took the third try worked, but he timely responded to the first notification, but he didn't get notified the second time about the issue with it. But in any event, both of them passed their background check and their fingerprints. They are licensed liquor store owners in Loganville and have a clean background, and the issues about the background check and the fingerprint, we've given you the paperwork on that, and hopefully the police department confirmed that. Addressing some of the legal issues. There are a lot of legal issues with this scenario of the initial application being submitted and then questions are raised and there's a supplementation of it. From a legal issue, I would call that the relation back doctrine. If you go file a deed at the courthouse and it's missing something that the clerk requires for filing, they don't accept it for filing. They don't take it and then say, well, it's wrong. So relating back, if you accept something for filing and say it's wrong, then you ought to give folks a reasonable chance to cure if there are technical issues. And here, the issues aren't of substance. Mr. Camp and Mr. Harrison passed their background check. They have a site plan from a registered engineer. That site plan was bigger than what they needed. They had a survey from a licensed surveyor who stamped their name on the document. All these were initial. When questions were raised about them, we answered the questions in a confirmatory way. It's not like we're missing a deadline and then we're bringing in information for the first time. We are clarifying. A lot of times in bids with the government, there's a period where you apply, and then if there are technical questions, you have a period to address those before the bids go live. That's similar to what we have here in that you're having to review it and you get to make that determination. But I would ask you to let things relate back, recognize substantial compliance, recognize substance over form, exercise equitable relief and fairness based on substance, recognize the good faith compliance here of having engineers, having surveyors, having the fingerprints done. Give my clients an opportunity to compete, put it into the lottery, and avoid having to go to court to straighten that out. And again, recognize you accepted this same property. That's something different than the other 3 appeals. You've already accepted this property on Park Place, Fars Road, right there next to Hampton Inn and the 4 restaurants with the access and the zoning and the traffic lights and all that in order, reduce the likelihood of litigation. They followed things in good faith. And also, I think you're going to hear an argument about files with the city, things on file with the city. When Mr. Sanders' letter was written, he was aware, based on the city's files, that this very property was compliant on the things that matter, and that's because Mr. Patel's application is already in there. So these are technical issues, not issues of substance and compliance. Again, you've got a hotel and 4 restaurants nearby. You've got the hospital nearby. You've got a lot of traffic in the area. You've got easy access to this location for residents where they could get to the property both through the main corridor of 124 and a lot of side roads. It's a very accessible location. It's very close to where we are right now here in the middle of town. I talked to somebody whose wife is a PA and he lives in the Brookwood area. She, goes to East Side Medical often, and I asked him, where do you go to the liquor store? And, there isn't one anywhere near there for all those employees nearby. And he has to go buy his Blanton bourbon way far away from Snellville. This is a high-quality operator. You're going to hear some of that from Ron Harrison, but we would ask you to exercise the kind of leadership that you were elected for, and recognizing that, we're not trying to pick on the city manager here. We answer this professionally and in good faith under the law about following up on good faith questions about the survey and the site plan and the fingerprints, and we would ask you to allow this application to go in the hopper. And at this time, I'm going to give some time to Ron Harrison of Beverage Store of Loganville to show the economy of scale that he would have in operating this store at high quality with the one in Loganville, and why that will serve customers well. So I'm going to reserve time to come up after Mr. Ron Harrison, but Ron Harrison, if you'll come on up.
Madam Mayor, may we ask questions of Mr. Reeves before going on to another person?
And I'd be glad to take up questions before I introduce Mr. Harrison. Absolutely.
I would prefer if the applicant stated their full case and then come back and ask questions.
Hello. Hi, Dave.
Mr. Harrison, if you can give your name and address for the record, please.
My name is Ronald D. Harrison, Jr. My address is 1860 North Aiken Drive, Atlanta, Georgia. I'm here on behalf of Loganville Package Store and the potential general manager of the beverage store of Snellville. In Loganville, I'm a 50% owner, and I serve as the general manager and the license holder. We opened the store in August of 2014. Since opening in August of 2014, every year that we've been in business, we've been able to increase our sales by double-digit growth every year, except for one, and that was the year after COVID, because we more than doubled the year prior, but the year after COVID, like any other small businesses, we had supply chain issues. But even with the supply chain issues, we were still able to have positive net sales growth that year. Currently, this year, we're still on target for double-digit growth. And the way that we went about achieving that amount of growth is from the way that we built the building. And I went to store after store after store before opening, trying to decide what makes a good store. And I wanted everyone that came in to the store to feel safe, whether they were coming in during the day or at night. We achieved that by building a building with really high ceilings, more lighting than we needed, just because we wanted everything to be bright and well lit. We put in about 35 high definition security cameras with a big giant display over the exits that showed everybody that was in the store that, hey, we're filming, we're watching, in hopes of deterrent from theft. And other than the building and being well lit and having wide aisles, we wanted to build a great staff. We have more employees than we need, just because we want to be interactive with our customers. We want to be able to answer their questions. We want to show them where our products are located. We want to educate them about the products. And all this is good and shows the pattern of our growth. And I have been recognized personally by the American Beverage License Organization as being the 2022 Retailer of the Year for Georgia. I've also been appointed to the board of directors of the Georgia Alcohol Dealers Association. And I think that I will be able to bring some experienced employees from Loganville to Snellville, and I think that I would be able to be a general manager at both locations, working with the same sales reps and the same distributors as that I currently do. Any questions?
We'll wait until you're done with the full presentation, and then we'll have questions. Thank you.
Thank you, Mayor. As you heard from Ron Harrison, again, there's a lot of hard work that goes into being the Retailer of the Year and on the board of the Georgia Alcohol Dealers Association. And, you know, with having the store nearby, he can, you know, instead of having a second layer of administration, he could have those two stores and pass those savings on to the customers so they could, you know, get high quality alcohol at the best prices. Additionally, with having all the the hospital employees and other women in Snellville who want to be customers there, having a package store with a track record of safety. If you think about those, you've got long hours. They're open on the weekends, and around Metro Atlanta, sometimes package stores have had problems with crime. This one has a track record of being intentional about having that extra layer of security and lighting, and their women customers in Loganville have recognized that, and they would look after their customers at this location. In Loganville, when they had that premature issuance and the litigation and all that, and you had 3 licenses issued, one of those folks went ahead and sold out and cashed out and flipped the store, and they're no longer in business. Ron Harrison, on the other hand, he is in it for the long haul. He's relatively young. He's a second-generation businessman here in the community. He wants to run this store and the one in Loganville economically for years to come, and take pride in having a local small business and not just, flip this store like some other people in the business do that. Dwight Harrison and Donald Camp grew up here in this area. They have decades of working hard in the community. Donald Camp joked that maybe his fingerprint was slowed down because he had rubbed off those fingerprints working so hard over the years. But we would ask you to recognize substance over form, cut through some of the technical issues, and recognize that, site plan, survey, fingerprinting, they did the best they could to comply with an application process that's technical in nature, but they filed on time the things of substance that matter. We would ask you to put their license in the hopper rather than putting this matter down at the courthouse where, things can lead to some unforeseen results.
Thank you, Mr. Reeves.
Thank you.
At this time,
I was going to say, you still have 7 minutes.
That might be a first.
are there any questions of the council for Mr. Reeves?
I might have one or two. Mr. Reeves, you alluded to some time after the application deadline. Did you read our ordinance and the requirements for application?
Yes. Go ahead.
And can you specifically tell me what the date and time was that the applications were to be submitted?
I was engaged at the appeal level, but I believe in this case, June was when the applications were due, and the applications were turned in. And that 90-page application, not the shorter one, but the 90-page with the Paulson-Mitchell survey and site plan and the Axis survey with the seal on it, they were submitted at that time. That makes this different than the other appeals. They submitted a site plan from an engineer, they submitted a survey from a surveyor, and they tried to submit their fingerprints and background check and all that, but they got that done when they were notified that it didn't go through the second time. So they filed everything on time, but when questions were raised about them, they timely cleared up those questions.
You mentioned a site plan by Paulson and Mitchell?
Yes.
Can you tell me what the date is on that, what you're calling a site plan?
Yes. If you go in Exhibit A and you go in page 86 as well as 87, it is stamped by an engineer at Paulson Mitchell, and these site plans were years old. They were not 2023 site plans. They were done in previous years. Ronnie D. Thomas is the seller. And
I'm quite familiar. What is the date on the site plan?
I would have to get a magnifying glass out to check that. The naked eye doesn't have that.
Well, my cheaters are better than yours. It appears that it's August of 2014.
Yes.
Okay.
That would be right.
And this is a development plan, not a site-specific plan. So you alluded to Exhibit B, where your applicant submitted a site plan. Can you tell me what date that was submitted?
Yeah, Exhibit B was submitted with the appeal.
Okay, so that was after the date in June?
Yes.
Okay.
And again, here's the difference. I think, and these are not defined terms, but I think that is splitting hairs to say there's a difference between the 2014 Paulson and Mitchell sealed engineering plan showing this property, and our application said it's that property that's highlighted right there. I mean, that is a site plan. It's much more detailed than other site plans for Maxi Price and Nico Patel that are already in the hopper. This is a site plan. The only question that Mr. Sanders raised is square footage. And we asked Paulson and Mitchell, what's the square footage? And they said it's 30-something thousand square feet. And so we said, we just need 10,800, and that's what we turned in with the appeal.
So you turned in a site plan for a building 30,000 square feet?
Yes.
That is your contention?
This property, yes. This building on there, if you look at Exhibit C or Exhibit B, we asked Paulson and Mitchell, tell us about that 2014 site plan. And he said it was a medical facility at that time, that vacant field across from Hampton Inn, 31,790 square feet. We said all we need is 10,800. So he showed a sketch of 11,250 square feet. That was the closest increment he could do. And then we went to Hill, Foley, and Rossi. I'm sorry, we actually got Paulson and Mitchell to draw it up. With Exhibit B, we redid it just to show the city that access, parking, building, and all that is sufficient for the smaller square footage, and that's in Exhibit B.
So the site plan showing the footprint of your building was submitted with your appeal. What date was that submitted upon?
August 20th, I believe. It's dated in the letter, August 22nd, 2023.
Thank you. I have no further questions.
But again, here's our position. If we go to court and we have a site plan and it shows you could fit a 30,000 square foot building on there and still have access and parking in the building, the fact that we went back when there was a question about we thought that the square footage was shown on there when we filed it. That's their position. When it was brought to their attention, the thing doesn't have the square footage on there. We actually learned that that building that was shown on there was bigger than they thought. And so we said, we don't need one that big. Show us parking, ingress and egress in the building, Paulson, Mitchell, you engineers, and they did that. And that's what you have in Exhibit B. So what you had to begin with showed ample access, building, parking, and we showed you that with the smaller building, you've got all that same. We also showed you that we've got easements for the restaurants so that if the parking lot's ever full, they've got a right to overflow in those restaurant parking lots. And also, again, the city qualified this property by accepting Nico Patel's application.
Thank you. Any other questions of council members for Mr. Reeves or the applicant?
Yes, I have one. Essentially, your initial site plan was done for and by Ronnie DeThomas?
I believe it was somebody previous to Mr. DeThomas. I think Mr. DeThomas owned the property. He bought it from those original developers.
So
I think Richard Swope was involved at some point, and I think maybe he's the one who drew it.
So you never provided a site plan for what you were actually going to build until the appeal?
They thought they did. They thought...
I understand that.
Yeah,
the problem
right.
I have is precedent, because we have other applicants who may have similar situations. So if you did not, in fact, meet the requirements, how can we say, okay, that's okay, and not give the same consideration to somebody else who may be much further afield?
Well, I'll state it this way. They can build a 30,000 square foot building. They can do that. They can build the one in the site plan that they put in there. They could put additional tenants in it. But they're exercising good faith. When a good faith question was raised about the square footage, they gave the city clarity on that point. But what they submitted was a site plan from an engineer with a building of more than 10,000 square feet. We've shown that. And as far as precedent goes, the first appeal and then the third and fourth appeal, the three other than ours, They don't have those issues, so you don't have any precedent. You can grant our appeal and not have any precedential issues based on the site plan or survey with the others.
Okay.
And again, there are liquor stores around Gwinnett and cities in Gwinnett that have multiple tenants, and these gentlemen certainly could build a 31,000 square foot building like the 2014 site plan shows, but they're here today in good faith to just ask to be put in the hopper based on their site plan and survey, and they've clarified they're willing to do the 10,800 square foot building that they clarified when they learned that the square footage was not shown initially.
Thank you. Any other questions of council for Mr. Reeves? I think my fellow council members have hit on my questions, so thank you, Mr. Reeves.
Thank you. We respectfully request approval and acceptance of the application.
Thank you.
Thank you.
We've heard from Mr. Sanders and then also the applicant, so I will entertain a motion.
Motion to uphold the city manager's decision of denial.
Second.
There's a motion and a second. We have a motion and a second to uphold the denial. Is there any comments for council? Then I will ask for the vote. All in favor of upholding the decision of the city manager, please raise your hand. That is 5 in favor. Any opposed? 1 opposed. Thank you all for coming out. And now we'll move to our third case. Our third case is from Jayton Shaw with Nico's Fine Spirits number 2 at 2752 West Main Street. Mr. Sanders.
This application, once again, was reviewed by the pertinent staff members, and after all the information was submitted, it's my decision to deny the application of Jayton Shaw for one specific reason. The property lacks access to a traffic light either directly or through easement. That was our finding.
Are there any questions of the City Council for Mr. Sanders? Nope. Then Mr. Ald, if you'll give your name and address for the record, then
Certainly.
You are off and running.
Thank you very much. My name is Warren Ald, and I am I actually live in Snellville, 2814 Williams Place in Snellville, and I am here today. I'm going to get my time down here so that we will. Here today representing Mr. Shaw and his application to seeking a license to sell distilled spirits by the package. The business is located at 2752 West Main Street, and if I can figure out how to work this particular item, I'll put it up. I hope that's not my eyes. Yeah, it's now. Okay. Technology. Thank you. Thank you, Jason. Yes, thank you very much. This is the location of the property. You will be familiar with it. It is located right at Fountain Drive, across from the old hospital, still the hospital, Eastside Hospital, right next to Gwinnett Clinic. You'll be familiar. It's on West Main Street, just down the road. We're here today asking that the mayor and council take a look at what we have filed in our appeal and to recognize that the failure to approve it was a mistake. In fact, there is access as required by the ordinance. It was information that was in the record and overlooked, not because of any fault, just it was there. And so the city does have constructive knowledge that this particular piece of property has the access that is required by the statute. A couple of points to point out. We do have a stipulation of facts, and I understand from the city attorney that that is part of the record. Is that correct? All right. And one of the first stipulations is, in fact, that the appeal and the documents that are attached to appeal are part of the record. So I know that everyone's had an opportunity to look at that. The issue here, again, is different from the prior applications. We were complete in our application. The application requirements were met. The only question is the piece of property. Does it have the access that's necessary? And again, it does. I'll point out to you that this is it is zone BG, acceptable for a store to sell distilled alcohol by the package. This particular piece of property is, any development of it is controlled by the Uniform Development Ordinance. And it's important to note that this is a BG piece of property because the uniform commercial property that is controlled by the UDO, all of them require interparcel access. It is part of the ordinance that the city of Snellville passed, and this property would be controlled by that. In fact, it is the statute UDO at 401-3-4 concerning vehicular access requires that internal vehicular circulation areas must be designed, and that's must be designed and installed to allow for cross-access between abutting lots. If cross-access driveway stub exists on an abutting parcel, the internal vehicular circulation area must connect to the stub to form a cross-access connection. The abutting piece of property that we're looking at, the Gwinnett Clinic, is just to the west of the property. It is 2764 West Main, and 2764 West Main was in fact developed some years back, but then it was redeveloped and had to come before mayor and council. And at the time it came for the redevelopment in 2019, it was in fact found to be under the UDO and required at that point to have a interparcel access stub in place. And that interparcel access stub was put in place. At the time of the, let's see if I can get this right. Let's get it this way so I know which way I'm looking. At the time it was put in and redeveloped, there was a stub that was placed in, and the stub, this is Highway 78 through here. There is a stub on both sides, and to the west of the property is an access stub that is on record and made a part of this particular piece of property. The property that we're dealing with is contiguous and next to it, and would itself be required by the UDO to have interparcel access connection here. And by the way, I will state that that is a part of the stipulation that the city has accepted, that is a requirement for any development of that piece of, that it have that access, that UDO access. Because the Snellville Code, the UDO requires that this interparcel access exist and be a part of both the development of the Gwinnett Clinic and any property to the west. Mr. Shaw, in presenting his application, came to the conclusion it wasn't necessary to do additional. It was there. not there by contract, it was there by law. It is required to be there. So it would have been duplicitous to, or it would have been adding to this application unnecessary information to do anything necessary. It was here. The city knew about it, or at least the city had constructive knowledge that it was here. The reason why the city would know it was there is that in 2019, when this piece of property was redeveloped, there was in fact a requirement that was issued by the Planning and Development Department of Planning and Development that required that before this piece of property could be developed, they had to have this in here, had this stub. Then, having placed the stub there, the city, through the Planning and Development Department, said, yes, in fact, you have met that obligation. So we know that the property that is contiguous to our property, that 2764, does in fact have the interparcel access. We also know that any piece of property, any development on the property that we're looking at, 2752 West Main Street, when it comes before this mayor and council, will be required to have the same interparcel access. So that's why we come to you saying that, in fact, it does have the access required by the statute. I can go on beating this horse, I think it's on the ground now, to make the point that it is here, but let me point out a couple of things, and that is that when the letter came back denying it, Mr. Shaw was a bit surprised by that, so he said what he would do is he would go to Gwinnett Clinic and just ask them, you know, is there anything else we can do here? And they said, well, let's do a potential easement agreement. Now, keep in mind, Mr. Shaw is not the owner of 2752 at this point. It's a contingent contract, contingent upon getting this application. So not being the owner, he cannot enter into an easement at this point. But he did. He went and said, just so to assuage any concerns that the council may have, is Gwinnett Clinic going to agree to participate in the ordinance requirement? And Gwinnett Clinic, through their owner, said they did. I attached as a part of our application a copy of an easement agreement. Now, this easement agreement was filed after the application. No question about that. Now, we're not saying it's part of the application. It is merely to let the council know that it can, in fact, it will in fact take place. In fact, at this point, I'd like to ask Mr. Shaw to come forward and have him tell you himself what he did and why he did it. Mr. Shaw, would you come forward, please? Would you state your name for the record and your address?
Jatin Shah, address at 824 Olmsted Lane, Duluth, Georgia 30097.
Take a moment to explain to the mayor and council, when you received the letter denying it, what did you do at that point as far as Gwinnett Clinic, and why did you do it?
I did talk with the owner of the Gwinnett Clinic, is Dr. J.J. Shah, and I know him personally. He knows me personally also, and told him the intention of doing this cross easement just for the records, and he told me that is already in place, but if you want, we can get it done, one more paperwork, and we did it that way.
And you did in fact submit a easement agreement that you obtained after the application?
That is correct. Okay. That is correct.
Okay. Thank you, Mr. Shaw.
Thank you.
So this particular access may have been hidden behind a few pieces of paper. We had to look a little bit. We searched for it. We found it, but that's it's certainly no fault of the city manager. But it does note that the city is on notice, at least constructively, that this access does exist. And so when we're looking at the issue of direct access or access through an easement, this piece of property does meet those obligations, those requirements. There's one other point I pointed out, we did talk in my brief about direct access. There is access through the stub, and by the way, I'll point out to you, the Gwinnett Clinic that's there, you may be aware of it, the Gwinnett Clinic driveway actually opens to the traffic light. It's one of about 2 pieces of property on 78 within Snellville that does. So when you talk about direct access, you can't get any more direct than that. We have the access across it. Now our actual driveway in this location is on the plat. It has been presented, but it hits about here. And we have submitted a survey with a seal from a surveyor showing the distance from the driveway to the signal here, 132 feet. And that survey is in the record, is also stipulated by the stipulations accepted by the city. The UDO, when it speaks about driveways and traffic signals, recommends that there be no driveway within 100 feet of a traffic signal. So you look at the question, what does direct access mean? UDO says you can't come open up to a stoplight. You got at least 100 feet away. We're 132, so we're well within what UDO is requesting. So there's this question of the meaning of the term direct access or even access in the code, and that's problematic. It was problematic for Mr. Shaw in this matter because he thought that he had the access. Problem we ran into is there's no place in Chapter 6 of the ordinance, the alcohol beverage ordinance, there's no place that the term access to a traffic light, either directly or from the licensed premises parking lot, is defined. It's not defined anywhere. Have no idea what it means. It is not defined in the UDO. It is not, no, there's no definition of words directly, direct, or access anywhere in the ordinance. It is not anywhere in the package that was sent by the city to the applicants. It is not in the letter that was sent to Mr. Jaden Shaw. It is nowhere defined, nowhere. One of the stipulations that are in the package that you receive is that when the Planning and Development Department of the City of Snellville reviewed the application seeking a license to sell distilled spirits by package, they were not provided an authoritative definition of the term access to the traffic light. That's the Planning and Development Department. They did not have an authoritative definition. Mr. Sanders did not have an authoritative definition. There is no definition. When he reviewed it, he was not provided with it. When he reviewed, well, the fact is, there exists nowhere in the code of the Snellville city, UDO, or in Chapter 6, in which we have any definition of what it means to have direct access or access to the easement. It's not there. And so the problem with this, it leads to a point of interpretation. It meant that the planning development had to come up with their own interpretation. Butch Sanders had to come up with his own interpretation. Mr. Shaw, as the applicant, had to come up with his own interpretation, and that's problematic. It is problematic because the statute requires, the law requires there to be some definitive statement on what a term means. This is an issue of due process. If in fact a statute or a law is vague, too vague without guidelines on how to use it, there is a question of whether it's unconstitutional. And in this case, if we look at it and we start looking at various determinations on the record, we don't know what they are. We don't know what Mr. Thompson used. We don't know what Mr. Sanders used. We do know what Mr. Shaw used. And we do know that there was some disagreement on what it meant. So there is this problem of unconstitutional vagueness that arises here. Now, what the UDO allows is that you can look at the dictionary. It actually states that in the UDO. You can look at Webster's Third International Dictionary and come up with a definition. And in the stipulation, we have language we looked at from the Webster's Dictionary, and the city has accepted this language, and it basically says it directly means without any intervening space or time in a straight line by the shortest way. The piece of property that we're looking at, and this is a survey. How do I bring it up, Jason? So it sees all of it. I got you. Actually, I think that's pretty good right there. Yeah, just a little bit. Thank you. This is a survey, as you can see, and push up a little bit, you see it is a stamped survey by Josh Lewis as a land surveyor that shows the distance between the signal and the driveway, 132 feet, as we've said. Now, the fact is that traffic coming from Fountain Drive or traveling along or even traveling west are able to reach this driveway directly. So what does that mean? What does directly mean? Well, we run into a problem with that because you have another application that you in fact accepted, and that application, actually two applications, at 1913 East Main and 1943 East Main. And both of those pieces of property were found to have direct access. But if you look at those two pieces of property, and this is 1913 East Main, you see that you have a drive. This is the area from Mr. Maxie Price's store, and this is Grayson Highway, Grayson Parkway, Highway 78. The existing drive 350 feet away. Now that drive is not directly accessed to a traffic light. If it is, then we know that the term direct does not have anything to do with distance whatsoever. This piece of property does have a proposed driveway up here that it has access to according to its application, but it's 300 feet away. So we have 300 feet, 350 feet. If that is direct access, then our piece of property is direct access. We're much closer to a traffic signal. We also have the access through the parking lot of the Gwinnett Clinic. The 1913, which is just to the red. This is 1943, excuse me, I just saw that. That was the one that is west of Grayson Parkway. The other application for Mr. Maxie Price is just to the east. You'll see that the proposed driveway, 260 feet from the light, or 300 feet from the light. So we get back again, even in the application here, the question of what is direct access is up in the air. We submit to you that Mr. Shaw's understanding and application of the term direct access as well as access across is reasonable, and as reasonable should be accepted. We don't want to have there to be guessing. We don't want there to be any concern about it. This is a reasonable determination when we don't have any type of authoritative definition. So ladies and gentlemen, it really gets down to very simple. And that is, we met all the terms, all the requirements of the application. And the question is access to this piece of property. It is reasonable to determine that access is found on this piece of property as required by the ordinance. Of no fault of Mr. Sanders, the city did have already determined that there's access. Ladies and gentlemen, we ask that when a motion is had, the motion is to uphold the appeal and to allow this application to be placed in the lottery. Thank you very much. That's all I have.
Thank you, Mr. Ald. Are there any questions of the council for Mr. Ald? Mr. Warner?
Well, you know, this has been my dream for 10 years. Warren will get that joke. Mr. Ald, was the development permit 19-11 in place at the time that the applicant put in place the application to the city?
No, I'm not sure if I understand your question, Mr. Warner.
You referred to the development permit 19-11 that the city gave to the adjacent property owner. Was that in place and in force at the time that your client put the application in with the city for?
Yes, it was.
Okay.
The application.
That's enough. Okay.
Okay.
The second question I have is, was the UDO that governs the interparcel access for that piece of property zoned to BG, was that in place at the time that your client put in their application for the liquor?
Yes, the UDO was in place at the time my client applied for the license.
Okay, thank you very much.
Are there other questions from the council for Mr. Ald? Nope. Thank you, Mr. Ald.
Thank you for your consideration.
And now that we've heard from Mr. Sanders and the applicant, I will accept a motion.
Why not? Motion to overturn the city manager's decision and accept the application.
Second.
There's a motion to overturn the city manager's decision and a second. Are there any comments by council? Seeing none, I'll call for the vote. All in favor, please raise your hand. That is 6 in favor with none opposed. So you will go in the hopper, as we say. Thank you. If we could, before we work into this next one, if we could just take a 5-minute recess. We are reconvening the meeting at 7:22, and we've got case number 4. This is Ms. Kelly Couts regarding Snellville Beverage Center, LLC at 2145 East Main Street. Mr. Sanders.
As in the three previous appellant cases, the application was fully reviewed by the appropriate staff, and this application was denied for one sole reason. It states the proposed location is within the TCO, the Town Center Overlay District, where package stored distilled spirits is a prohibited use. Is the sole reason.
Thank you, Mr. Sanders. Are there only any questions of the council for Mr. Sanders?
Yes, I have a question for Mr. Sanders. As far as the Muni Code is concerned, was that updated?
The Muni Code?
Yes.
Everything was submitted to Muni Code.
But was it updated before the applicant put her applications in?
I can't speak directly to that. I know everything was sent, and that is to be determined.
Thank you.
Mr. Sanders, I do have one question. Hey, can you hear me? That wasn't my question. The Town Center Overlay District, when was that put in place? Do you recall?
Jason might be able to speak more to that. Was it 16?
16 or 17?
When it was extended to
district?
cover the area that this...
The Town Center overlay.
2019, okay, thank you.
Thank you. Any other questions for Mr. Sanders? Okay. Ms. Couts, if you'll give your name and address for the record, please.
Thank you, Mayor and Council, for allowing us to be here tonight. My name is Kelly Couts. I reside at 3085 Sawgrass Trail, Wilbur, Georgia, 30047. I'm short. I don't know if I can pick me up. Sorry. Thank you. And you're going to have to bear with me because we have to make a record, because if this is appealed, it has to go to Superior Court, and they just look at the record. So if I start talking some legal language, that is to protect the record. I have to make some preliminary motions. This application is on behalf of myself and Rahim Asani. Rahim couldn't be here tonight. He's away on business. And we have together the Snellville Package Center, LLC. Before we start, I would ask that the application, our application, be adopted and be made part of the record. The city has the original of that application, and I'd ask that that be Exhibit 1. And unfortunately, before I start, I have to remind you all the reasons you may or may not like me, because I have to put on the record a motion to recuse some of you. The due process under the United States and the Georgia Constitution says that you have a right to an impartial and unbiased decision maker. That applies not only to this process, but also the process of Mr. Sanders in deciding the application. And unfortunately, you guys all know who I am. I'm former mayor of the city of Snellville, and I originally ran against Barbara Bender and defeated her in the race for mayor. In addition, in my course this time as mayor, I had to file a lawsuit against the city and against members of this mayor and council individually. That included Mayor Bender and also council member Emanuel. And so I would have, as Exhibits 2 and 3, and I'm going to hold them till the end, so I'm not going back and forth. If you want them now, let me know. I do have a certified copy of the complaint. That's in case number 14-A0747-9 is Exhibit 2. Exhibit 3 is a certified copy of the complaint, and that's 13-A0226-8. With Councilmember Emanuel, not only was he involved in the lawsuit, there's a history where he attempted to press criminal charges against me. He wrote numerous blog spots, and so as exhibit number 4, I have excerpts from his Cut to the Chase blog that he wrote back when we were in city council, and there continues to be disparaging remarks by both Mayor Bender and Council Member Emanuel. And then Councilwoman Schultz, you were not involved in those lawsuits. However, I do believe that there were times that you made public comments in the meetings against me, continue to make disparaging remarks on Facebook and in public, and unfortunately, I was part of the force that terminated your daughter when she was the director of the planning department here in the city of Snellville. So for those reasons, I would ask that those members of the mayor and council recuse themselves from this vote. Okay.
Do any of those members of council choose to recuse themselves? Thank you. You may go on.
Okay. I also have to object to this process for a lack of notice. I would ask that exhibit number 5 be an email from me to the city clerk and the city attorney asking when the date of the hearing would be. That was dated on September 5th, 2023. Again, an email was sent with our letter later that afternoon on September 5th, 2023, notifying us that the appeal hearing would be held today, which is September 11th, 2023. Because of the timing of the notice, there was not time to do open records. There was not ample time to do open records requests to get all the records that would be necessary. I understand that open records requests were not required. Excuse me, let me back up. That email had a letter attached to it. That letter was actually dated September 5th and received by certified mail on September 8th, 2023. I'd ask that that letter be marked as Exhibit 7. Exhibit 8, I'm asking that the email for certified documents from the city clerk and the city attorney dated September 6, 2023. It's my understanding that Mr. Ross said we don't need necessarily certified documents. However, not all the documents are available on the city website because minutes are not archived past a certain date. And by notice of this hearing, there was not 3 days to have the city open records request. I also have to object to the process because the ordinance lacks specificity, and what the process is, your letters and your follow-up procedures also lack that. Due process requires that we have the right to have witnesses. We have not been afforded that right today. And I believe it also, the ordinance as it's written is vague, ambiguous, that no rules are given. Also, I believe there's an equal protection clause violation because Chapter 6, the alcohol ordinance is governed by Chapter 6, Article of your
Snellville Code of Ordinances, which provides for licensings of alcoholic beverages. It's also, in my denial, is going to go to Chapter 200 of the UDO, but Chapter 6 goes to alcohol licensing, what this application was. And specifically, Chapter 6, Article 5, Section 6-153 provides that no license shall be denied, suspended, or revoked without the opportunity for a hearing as provided hereinafter. And that hearing as provided hereinafter is in front of an alcoholic beverage review board. And your ordinances go on to provide that in front of the Alcoholic Beverage Review Board, you have the right to an attorney, to cross-examine witnesses, and other due process requirements that are not afforded to the applicants in tonight's hearings. And so the applicants for tonight's hearings are being treated differently than applicants that are appealing under other alcoholic license denials. So I have to object to these processes on those grounds. In addition, the denial of my application is based on the UDO, and the Board of Appeals was specifically created in Chapter 2 of the Snellville Code of Ordinances. Chapter 100 of the UDO, Article 3, Section 103-7.2 says any appeal of any decision by any staff member based on the UDO should go to the Board of Appeals. And the Board of Appeals provides, again, for more due process requirements and also for a longer time for appeals. So I have to object to this process based on that as well. Also, I'd like to back up, and there's an email also dated 8/17 from the city attorney, between the city attorney and myself, and I believe he's also explained that tonight, but where he said subpoenas would not be necessary because this was non-adversarial process, and so they would not be available. I'd ask that that be made Exhibit 9. Before I get started, I would ask that Exhibit 10 be a certified copy of the Snellville City Charter, Exhibit 11 be a certified copy of Chapter 1 of the Snellville Code of Ordinances, Exhibit 12 be a certified copy of Chapter 2 of the Snellville Code of Ordinances, Exhibit 13 be a certified copy of Chapter 6 of the Snellville Code of Ordinances, and Exhibit 14 be a certified copy of the Snellville UDO Chapters 100 and 200. So I want to get to my application now. You guys know my name is Kelly Couts. I've been an attorney in this area. I was born and raised in this area. No longer live in the city limits of Snellville, but live still over by the Brookwood High School. My partner is Raheem Isani. He is also a business owner in this area. He owns the development where the Pizza Hut is, there at Scenic Highway and Oak Road, and so we are both well established in the community. We are good stewards of community resources and of the community, and it was our goal to open and operate this liquor store here in the city of Snellville. I would adopt the same reasons that I said with the motion to recuse in arguing that the city manager, which law says that it can be applied, that due process rights of an impartial and unbiased decision maker can apply to executive decisions, and so I'd adopt those same arguments for the city manager. And so, as Mr. Sanders stated, our application is unique. Can you see this? Thank you. I think I left off a copy of, I'd ask Exhibit 15 be a copy of Section 22-49, Chapter 22, Article 3 of the Snellville Code of Ordinances, and Exhibit 16 be the written appeal, my written appeal without exhibits. There is a typo in the header of that. It says 2345. That should be 2145. And Exhibit 17 be the denial letter that I received dated August 2nd, 2023. I'm asking that this be Exhibit 18. This is a letter that we received through an open records request. This is from the planning department that shows, you can see in red, those are the problems for each applicant. And so as you can see, our application was 100% complete and in compliance. The only red we have is that red Y where it says, is the property located in the TCO district? Now, I would ask that this letter be made Exhibit 18. I would ask that Exhibit 19 be a letter that was written from Police Chief Greg Perry to Mr. Sanders stating that the police department has no problems with any of the, enforcing any of the ordinances in any of the property, and any of the applications. Now, it's undisputed, we don't disagree, that our property is on the edge of the town center overlay. And this is, I'm asking that this be Exhibit 20, official zoning, copy of the City of Snellville official zoning map from 2020. We are the red area on Highway 78 going towards Loganville, right? We are one of the last businesses in the town center overlay. We are zoned business general, there's no dispute about that. We are not in the town center residential or the town center mixed use zoning classes, but we are in the overlay district. This area, I think you guys are all familiar with it. It's the vacant old Walmart, and what the property we're looking at is the car wash, and so it is a blighted area. Most of these businesses are vacant, and the car wash has been vacant for about 2 years now. Most of the businesses here in the shopping center are also currently vacant. And so I'd ask that these aerial photos be made Exhibit 20 that show the area that we are looking at, and it's our position that this will improve that area and the blight in that area. In our application, we did comply with the zoning requirements and the aesthetics of the town center overlay district. And you can see, you can see that some of those things in our rendering and also in our site plan, which we did include a detailed site plan that was specific and current for this site. Permitted uses in the town center overlay district include halfway houses, cell towers, event facilities, hotel, motel, extended stays, video arcades, pool halls, billiards, bowling alleys, shooting ranges, all office uses, bus terminals, fortune tellers, laundromats, massage parlors, nail salons, and tattoo parlors. Permitted uses in the town center overlay district also include wineries, brew pubs, beverage stores, bottle shops, distilleries, convenience stores, growler shops, and pawn shops, which are similar uses to a package store. I would ask that the aerial photos be Exhibit 21, the renderings of the proposed building be Exhibit 22, and the license application by the City of Snellville that your city published and put out be Exhibit 23. And I understand y'all amended that, and I believe Ms. Arnold gave me both copies, and so that would together would be Exhibit 23. They, if you look at the license application that you guys published, there is no mention that the liquor store cannot be in the town center overlay district. There's several requirements in there that it has to be on a principal artillery road as defined by the long-range plan, has to be a half an acre, has to be adjacent to a red light. There's several things in there that it can't be. It can't be close to a school, it can't be close to daycares, it can't be close to a church, but nowhere in the application does it mention the TCO. Ordinance 23-04, which amends Chapter 6 of the Snellville Code Ordinance, makes no mention of the TCO either. And again, you have very specific regulations in there of where it can and where it can't go, but there is no mention of the TCO, or the Town Center Overlay. And so I would ask that the certified copy of Ordinance 2304 be marked as Exhibit 24. I would ask that you guys amended both the UDO and Chapter 6. You passed Ordinance 2304 and you passed the UDO 2301 at your council meetings on February 13th and February 27th, 2023. I would ask that the certified copies of the videos from those work sessions and public hearing meetings be Exhibits 25, 26, 27, and 28. And Ms. Arnold, I do believe I gave you some of those originals when I turned in my application. I'd ask that those be made part of the official, not application, appeal. I'd ask that those be made part of the official record. If you watch those meeting videos, there is no discussion. There's discussion again of where it can't and can't go, but there is no discussion of the town center overlay. When Mr. Thompson is presenting or giving his presentation of what UDO 23-01, what is changing, there's mention that it's adding the package store, but there is no mention that it cannot go in the town center overlay. The only place that it's mentioned of what the uses are in the town center overlay is in the UDO Appendix A, Chapter 200, Article 6, Section 206.2, and that is the permitted table use for uses of the city of Snellville. And the city of Snellville is unique. Can you still hear me if I step over here?
We can hear you, but it'd be better if you were on the microphone to make sure it got on the video.
The city of Snellville is unique in that some places, if it's blank, it means it's not allowed. But the city of Snellville actually has in their UDO, and this is a key, and I do have, these are going to get out of order, but it's fine. I do have a certified copy of the City of Snellville Unified Development Ordinance, Chapters 100 and 200, as updated through Supplement 30. And so this is after you passed it in February, what it applies to, and this chart is the same that I've printed here. And I'll ask that that be made part of the record. I think I already tendered that in with the code sections earlier. But if you look, there, a line means not permitted. And this is one page. All right, Jason, can you pull it out for me some? Yeah. Thank you. And so if you go here to package store distilled spirits, TCO is this first box. It is blank. There is no line through it. That is certified by your city clerk that this is the official code of the city of Snellville. There is nothing in that box that prevents there from being a package store in the TCO district. Now, there is a difference in a zoning class and a district. A district adds extra requirements. So yes, you have the requirements that it has to be in BG or HSB, but there is nothing that prevents it from being in TCO. Now, all the other boxes are filled in with the line where it's not permitted, but in this box right here, it is blank because there is nothing either in the written ordinance or in this table that prevents it from being in the TCO district. And unlike other jurisdictions, Snellville doesn't say that if a use is not specifically permitted, it's disallowed. Section 206-1.3 says that like uses may be permitted, and remember the TCO, growlers and bottle shops and wine stores and those things that are like uses are permitted, that they may be permitted. And so there is nothing in the UDO or in the Snellville Code of Ordinances that disallows this development from taking place in the location. Now you may say that that blank doesn't mean it's allowed. Well, then that means that the law is ambiguous and it's void. Because if the law doesn't give someone reasonable notice of what is allowed and what is disallowed, then it is unconstitutional for vagueness and ambiguity, and it is null and void. I also, for the record, would challenge the passage of UDO. The state of Georgia has certain requirements as found under Title OCGA 36-66. It's called the Zoning Act or the Zoning Procedures Act, and they are the minimum requirements that you must have before you can pass zoning laws in the state of Georgia. And those laws, where's my cell phone? Are the bare minimum, and 36-66-5 specifically states that policies which govern calling and conducting a public, prior to the adoption of any zoning ordinance, a local government is required to conduct a public hearing on the policies and procedures for conducting public hearings. In addition to policies and procedures required of this, by subsection A of this code section, each local government shall adopt standards governing the exercise of the zoning power, and such standards may include any factors which a local government finds relevant in balancing the interests, promoting public health, safety, etc. Such standards shall be printed, and copies thereof shall be available for distribution to the general public. So before you pass the UDO, because in 2020, October of 2020, you repealed your zoning ordinances and you replaced it with the Unified Development Ordinance. Before you did that, you were to hold a meeting adopting the policies and procedures that you were going to have govern all of your zoning decisions. And you're to have those written policies and procedures at every council meeting in the back, just like you have your agendas, for someone to pick up so that they know what those policies and procedures and what those standards are. You're to have them not only when you adopted the UDO in October 2020, but at every future council meeting. And so the minutes, when you pass the amendment to UDO 200, Chapter 200, in February of this year, those standards were not there. Those policies and procedures were not there. When you adopted the UDO in October of 2020, those policies and procedures were not there. So I would ask that Exhibits 30 be the minutes from the October 12, 2020 public hearing. Exhibit 31 be the minutes from the October 26, 2020 public hearing. Exhibit 32 be notice for the February 13, 2023 work session and public hearing. Exhibit 33 be notice of the February 27, 2023 work session and public hearing. Exhibit 34 be notice to amend the UDO 23-01. Exhibit 35 be the Planning Commission agenda from January 24, 2023. Exhibit 36 be the Planning Commission minutes from the January 24, 2023. Exhibit 37 be the agenda from the February 13, 2023 work session and public hearing. Exhibit 38 be the minutes from the February 13, 2023 work session. Exhibit 39 be the minutes from the February 13, 2023 public hearing. Exhibit 40 be the agenda from the February 27, 2023 work session and public hearing. Exhibit 41 be the minutes from the February 27, 2023 work session. And Exhibit 42 be the minutes from the February 27, 2023 public hearing. Our position is that nothing in the Snellville ordinances as published, as certified by the city clerk, prevents there from being a package store in the town center overlay district. If it does, then there's ambiguity and it is null and void, but it is also null and void because you have not complied with state law in adopting these policies. That would not affect Chapter 6, which is the alcohol ordinance, but it would affect the UDO. Any questions?
Are there any questions of the City Council for Ms. Couts? Mr. Warner.
Ms. Couts, are you going to submit all those exhibits to us to review before making a decision tonight?
Except for 3 or 4 of the single page ones, they were all attached to my appeal.
Okay, all right.
But I'm happy to give you, I have these to give to you now.
It just sounds like a lot, that's all.
Yeah.
Any other questions of council for Ms. Couts?
I'm sorry, there is one last exhibit that is a request for an open records request that was done back in June that has yet to be fulfilled, asking for emails between the mayor and council and city staff on this. Can I approach to give you the exhibits?
Sure. Any other questions? Okay, then I thank you, Ms. Couts. I will entertain a motion.
Motion to overturn the decision, the city manager's decision to deny the applicant the Snellville Beverage Center.
There's a motion to overturn the city manager's decision. Is there a second?
Second.
There is a motion and a second to overturn the city manager's opinion. Is there, or decision? Any comments by council members?
I'd like to make one. I've reviewed our ordinance during the applicant's presentation. Nowhere in our ordinance did it specifically say that Town Center Overlay District was excluded. Ms. Couts was not on council or mayor at the time when we did adopt that, so I would request that you join me in overturning Mr. Sanders' decision.
Any other comments by council? Then seeing none, I will call for the vote. All in favor of overturning the city manager's decision, please raise your hand. That is 6 in favor with none opposed, so you will go in the hopper.
Thank you.
Madam Mayor, may I be heard?
As far as, Mr. Reeves, as far as the matter that you've already been heard on?
No, to request reconsideration based on other matters subsequent to mine.
I would suggest, Mr. Reeves, that probably is better left for an appeal if you're gonna file an appeal.
This is the appeal.
I'm referring to a Superior Court appeal, I guess. I mean, you're certainly welcome to make a motion to ask this council for reconsideration. There's not a procedure in our code for that, but you're certainly welcome to do that. But you're kind of off the script at this point.
Right.
So.
Well, I think the courts would want us to exhaust our remedies before the city, and in light of the decision, particularly on the third appeal, with the reason the city gave of things being in existence and on file in city records, that Paulson Mitchell site plan was on file with the city. It led to the permitting of Hampton Inn, 4 restaurants, and the city had on file the square footage of that building, as well as Nico Patel's application that had a square footage showing that access, square footage, parking, all were satisfied. So based on the reasoning on the record by the city tonight, that the city is going to rely on records in existence of the city's files, I would respectfully request that you reconsider the decision on my client's application. Additionally, in light of the fact that Nico Patel's application is in the hopper, if there's litigation concerning this property, that's something that could place the whole process in jeopardy, with this one also being in court. So for those reasons, I would ask for the city to consider this, possibly enter executive session briefly to review that. But an ounce of prevention is worth a pound of cure, and we have some simple requests based on reasoning that the city has applied at this very meeting tonight. We would ask you to treat Donald Camp and Dwight Harrison equally with how you treated Mr. Shaw relating to records on existence with the city.
Thank you, Mr. Reeves.
And also recognize that Nico Patel's application is the same property, and issues relating to this would affect his in the case his is drawn.
Thank you, Mr. Reeves.
Thank you.
Thank you, Mr. Reeves. We are going to go ahead and end this hearing for the evening. Everyone has been heard and the vote has been taken. Your appeal would be then to Superior Court.
Okay.
And with all of the cases being heard and decided tonight, I will entertain a motion to adjourn the meeting.
Motion adjourned.
There's a motion. Is there a second?
Second.
There's a motion and a second. All in favor, please raise your hand. That is 6 in favor with none opposed. And we are done. Time 7.